there, thanks for joining me again. In this video, I want to address 5 ways that you can be considered inadmissible to Canada. The first is under security grounds, so I can read it real quick for you so you understand what I mean, and then I'll explain it. An officer has reasonable grounds to believe that you are engaging or will engage or have engaged in an act that will breach security. So essentially, if the officer believes that you are a security risk to the citizens of Canada, then you can be considered inadmissible and be denied entry to Canada. The second is criminal grounds, which many of my clients fall under this. And this is, again, a conviction outside of Canada may be equivalent to an offense in Canada and may be subject to inadmissibility. Common inadmissibilities that we see are DUIs or DWIs, impaired driving, things of this nature. Also misdemeanor offenses. But again, it doesn't mean that just because it's a misdemeanor or a felony offense that it is considered a criminal ground. The point here is that it is equivalent to an offense in Canada. So if we look at the laws of wherever the offense occurred, should that offense be considered an offense in Canada, then you're considered inadmissible. However, if it's not an offense in Canada, then it's not an inadmissibility, which means you don't require a document to overcome that inadmissibility. So the equivalency is very important. The third is health grounds, and there is a list of health inadmissibilities depending on what applications you're filing and so forth. Not all inadmissibilities apply under the permanent applications and not all apply under the temporary. So it really depends on what you're applying for and also what the held inadmissibility is all about. So I'll quickly read it here. Every foreign national upon entry into Canada requires a medical certificate indicating that they're not inadmissible on health grounds based on the last medical examination. And that medical examination is done within 12 months. Again, depending on what application you're applying for, you may not require to do a medical examination. However, if it is requested from you, you have to obviously comply and provide that. And based on what you're applying for and what is listed on your medical records, you may be considered inadmissible. The fourth one is financial grounds, and I'll read it. There are a lack of resources to provide for yourself and your family members. Financial grounds under most application, there is what they call a LICO requirement or a low income requirement for many applications. And then there are applications that don't have a LICO requirement, but they have a rule of thumb, if you will. So for example, a visitor visa application, there is no real LICO requirement for that, but they do recommend that you have about $10,000 to show that you will have to be able to support yourself and your family stay in Canada. So if there's not enough finances to support your stay in Canada, then you may be considered inadmissible under financial grounds. And the last one is misrepresentation, which I'll read. Any material facts related to a current application which is either withheld or misrepresented is grounds for inadmissibility. So this is very important. It's essentially misrepresentation is either providing false information or withholding information from the officer. Now, sometimes clients come to me and say, you know what, I didn't know I was responsible for this, or I didn't know this was important, I didn't intend to. The intent is not important, essentially. If you provided false information or withheld information, whether you intended to or not, you may be considered inadmissible to Canada. To overcome the inadmissibility, you would have to apply for a temporary resident permit and/or a criminal rehabilitation. For further information on this, please see the relevant videos on this. Until next time, thank you.